Okay, so welcome to this podcast entitled Co-Ownership. This is the first podcast we'll do on this topic. It'll go for about 15 minutes. It's really just an introduction to the area of co-ownership. And we'll be talking about the two main types of co-ownership being joint tenants and tenants in common. So in this unit, there are really, I suppose, three questions that we'll be looking at that can arise. The first is, well, what is co-ownership and how can one be created? That's the focus of this podcast. And in later recordings, we'll talk about what the rights are between co-owners once a co-ownership situation is actually on foot. And then the third question, how can co-ownership be brought to an end? So what are we talking about when we say co-ownership? Well, essentially what we've got is a situation where two or more people have an interest in the same piece of land, including the buildings, at the same time. So the key things you need to remember are we're talking about the same piece of land, and we're talking about two or more people having an interest in the estate. There are two main types that we'll be talking about in this unit, and indeed really only two main types in Anglo-Australian property law. These are tenants in common and the joint tenancy. So we're talking about co-ownership of what? Well, we're talking about co-ownership of the real property. So as you might remember from a previous podcast, we talked about the fact that land includes the physical land and that people can have an interest allocated to them from the state in that land. The land also is broader than that and includes the buildings. It doesn't, however, include things like personal property, which we talked about in the previous podcast as being chattels. You can see from those three pictures there's a commercial premises that can be owned by two or more people at the same time. There's also an apartment building in that complex, so you might think of that and talk about this when we get to the concept of community titles. But if you can conceive those separate individual apartments or those units within that building as potentially being owned by either one person, i.e. Unit 5 is owned by one person, or Unit 5 could be co-owned by two or more people. Okay, so let's quickly talk about the concept of tenancy in common. This is one of the forms of co-ownership, the other being joint tenancies. The distinguishing factors of a tenancy in common, or tenancy in common, is essentially that the co-owners have a distinct share in the property. That doesn't mean that they own, for example, the back half of the property or one of the bedrooms of the property. They have an entitlement to the entire physical space of the land and buildings, but rather, in terms of a conceptual way of distinguishing their share, we can say that they have a fraction of ownership of an interest in that estate. So, for example, it's a fee simple lot, and if you look at that picture on the far right with Mario, Luigi, and Mr. Dinosaur, you can see that the three of them can be co-owners of lot 1. Alternatively, there could be 3 separate lots, in which case they're not co-owners at all, they're individual owners of those lots. But in the far right picture, Luigi could have 1/3 share, the dinosaur 1/3 share, and Mario could have 1/3 share as well. Alternatively, there might just be 2 of them, if it was Luigi and Mario, and they could have a 50% share each. And you can see that really we're talking about their distinct fraction share in the property. One of the the other distinguishing features of this is that their share can be left to whoever they want, or indeed alienated during their lifetime, to another person. So, for example, if Luigi dies, his share will not automatically go to Mr. Dinosaur and Mario. Rather, it will go in accordance with his will, and that person will inherit the share that Luigi had in the estate. On the other hand, we have a situation of joint tenants, which are not separated by individual shares in the property. And it would be incorrect to talk about joint tenants as having some form of fraction share in the property. Even if there are 2 or 3, we cannot say that they have 50% each or 33 1/3 each. Rather, they own one and all of the property together, jointly. Again, they have the rights to physical possession of the whole of the land. So that's similar to tenants in common. The main difference that you would need to recognise is that this right of survivorship can apply, such that if Luigi passed away, his share in the joint tenancy would automatically go to the remaining 2 joint tenants. And we would say that their share has been enlarged to that extent. So they would then own basically 50%. You can conceptually think of it as 50%, but it's not a percentage as such. On the other hand, or in addition, if Mario passed away, then his share would go to Mr. Dinosaur or the surviving joint tenant through this concept of right of survivorship. So that's a big difference, because you can imagine that in certain circumstances, a person might not want their share to actually transfer automatically to the other co-owner. So as I mentioned before, in the situation of tenants in common, those individuals can decide where their share goes. They can indeed alienate it in their lifetime to whoever they want. They cannot, however, deal with the entirety of the estate without having the agreement of the other co-owners, and in such a case, the co-ownership is likely to come to an end if they, together the 3 of them, decide to, for example, transfer it to Mr. Mushroomhead in the right-hand corner. So if they did that, what would happen is you'd have a termination of the co-ownership arrangement. Right, but the purpose of that slide is really just to show you that those individuals in a tenancy in common arrangement can deal with their interest in the property separately from the other tenants. So how are co-ownership situations created? Well, essentially there are 2 views on this. There's the view that equity has and the view that the common law has. These have both been displaced somewhat or overridden by legislative intervention, which we'll get to in a second. For the main part, you can think that a joint tenancy could be created by using express words. For example, to A and B as joint tenants. So if I have a property in my will and I want to leave it to my sons, and I want my sons to inherit as joint tenants, I might say something like that. On the other hand, if I want to have them holding the property as tenants in common, again I use express words. The presumption was, if there weren't any express words, it just said to A and B. Common law said, well, they're joint tenants, and equity said they're tenants in common. The reason for equity thinking that they should be tenants in common was really around that right of survivorship, which can act relatively harshly in circumstances where the people taking the interest in the land are not necessarily a married couple or a close couple who would actually want the right of survivorship to apply. So therefore, equity viewed them as their interests being tenants in common. So in reality, in today's modern life, what will happen, and we'll talk about this system of registration later on in the course, but I'm really bringing this form to your attention now so you can see practically how this would play out today, is that if myself and another person were to purchase a property together, on the transfer document we would put our names. You can see in item 5 there, and we paid for the money for the property, and that would come under the consideration, item 4. The transferor would be the seller or the vendor, and as the transferee, we would put something like tenants in common if we wanted to hold as tenants in common. Let's just say it was my partner and myself. On the other hand, if we wanted to be joint tenants, we'd write joint tenants in there. If there were 2 of us, but we wanted to hold in different shares rather than 50-50 or half each, we might say something like my name as to 1/3 share, and the other name as to 2/3 share. And that would specifically separate on the title my interest as being distinct from the other person's interest. So let's just say that transfer was registered, and we'll talk about this system of registration and transfers later in the course, so don't worry about too much for the moment. Then how it would show up on a search of that piece of property is as follows, and you can see in this example we've got John Smith and Jane Smith owning as tenants in common. John Smith has 3/5 interest and Jane Smith has 2/5 interest. So together that adds up to 100% interest in the property, but you can see that they've got a distinct share as co-owners. If it was joint tenants, there wouldn't be an interest as a fraction there, because it's not possible. The tenants together, the joint tenants together, own one and all of the property. Sometimes you can get difficulties in the words of creation of a particular co-ownership arrangement. So these cases came before the introduction of the Property Law Act, but even still there are circumstances where today someone might use words which are slightly equivocal or not particularly certain. So for example, in these 2 cases, which you'll look further in your tutorials, there were words used that said, I give this property to A and B in equal shares as joint tenants, or to my children in equal shares as joint tenants. Now that wording is problematic because well, joint tenants, we know, don't necessarily have equal shares. They don't have unequal shares. They've just got a share. And that share is, for want of a better word, shared with the other joint tenants. So you can see how that wording might imply that the giver of that piece of property might have actually intended them to be tenants in common. So that was problematic, and the court looked at the circumstances in that case and came to a decision as to whether the property should have been given as tenants in common for a joint tenancy. Similar situation happened in Re Barber. Said share and share alike as joint tenants was in the disposition. Now that again creates problems because as joint tenants, it implies that they're holding it equally or in some sort of 50-50 share, which of course they're not. As joint tenants, as I said before, they own one and all of the property, and it's not possible to divide up their particular share. So have a look at those cases, which you'll go further into in your tutorials, about how the court deals with those situations. So today, under the Property Law Act, we now have a provision, section 35, which basically reverses the common law presumption that co-owners would take as joint tenants. And you recall from the previous slide that I said that the common law had always thought, well, if there was going to be a disposition of real property or an interest in real property, that they were going to take as joint tenants. Equity, on the other hand, said, well, the right of survivorship could operate too harshly in certain circumstances for people who aren't necessarily close family people that might own it for other reasons, so therefore equity saw it as tenants in common. We now have Section 35 of the Property Law Act basically reversing the common law position and saying a disposition of an interest shall be presumed to be as tenants in common. So you can still create a joint tenancy, of course, and you can see in subsection 2 there that it won't apply in circumstances where where the disposition actually says that they're going to take as joint tenants. But if it says in the will, for example, so-and-so will take as joint tenants to share and share alike or in equal shares, then this creates these sort of equivocal words which we talked about in the previous slide. Some of that case law might be relevant to determining how those co-owners actually hold the interest in land. Section 35 of the Property Law Act is also supplemented by Section 56 of the Land Title Act. So the Land Title Act, as we'll get to in future podcasts, is the piece of legislation we have in Queensland deals with the registration of interests in land. And this Section 56 says, well, in registering an instrument, that is, for example, the transfer document, which I put up in a previous slide, the registrar, the departmental person, must register the co-owners as holding their interests as either tenants in common or joint tenants. So if it doesn't say, then you see subsection 2 says we're going to presume that they hold as tenants in common. So that's it. Just to recap, basically in this podcast we're talking about what co-ownership is. There are only 2 forms of co-ownership today, really: joint tenants and tenancy in common. Joint tenants carries that right of survivorship, which can operate harshly in some circumstances. And towards the end, we considered that, well, basically these common law presumptions that a 2 or more co-owners would take as joint tenants is now no longer the case unless they specifically say that these people are to take as joint tenants. Question then arises, I'm sure most of you are asking, why on earth would I decide to set up a joint tenancy? Well, in some circumstances it makes it easier for the transfer of the estate to happen very quickly. So on someone's death, the right of survivorship applies automatically, and no one needs to worry about too much about the processes of probate, which can take a long period of time. Right, that's it. We'll talk more about co-ownership in the next few podcasts.